Get these black kids out of my courtroom. Your Honor, this is a courthouse, not a daycare.
Wesley Lewis stood still, 18 years old, white shirt, hands steady.
We're here to represent our grandmother, sir.
Gerald turned slowly, looked Wesley up and down like something stuck.
Represent? You can barely represent yourselves in decent clothing.
The courtroom laughed, every row, even the bailiff smirked. Willa picked up the papers Gerald had knocked off their table. Wesley didn't move, didn't blink. Their grandmother watched from her wheelchair, silent, her paralyzed right hand resting where it always rests. Nobody in that room knew it yet, but those scattered papers held one question that would end Gerald Haynes's career before lunch. I'm not gonna lie, that courtroom got real quiet real fast after this. Let's get into the story. Colton Springs, Georgia, a small town where everybody knows your name, and your skin color decides how they say it. Cedar Hill sits on the east side of town, 2.4 acres of red Georgia clay, old oak trees, and a white clapboard house with a porch swing that hasn't stopped creaking in 40 years. Dorothea Lewis bought that land with her husband in 1962, back when a black couple buying property in Colton Springs meant signing papers in a back room, while white folks used the front door. Her husband worked 3 jobs to make the payments. He never missed one. 3 generations grew up on that porch. Dorothea raised her daughter there. Her daughter raised twins there. And when a car accident took the twins' parents 12 years ago, Dorothea raised Wesley and Willa there too. She was 63 then, already tired, already grieving. She raised them anyway. Dorothea taught elementary school for 38 years in Colton Springs. Every black child in town passed through her classroom at some point. She taught them to read. She taught them to speak up. And every single one of them called her Miss Dot. In 2019, a stroke took the use of her right hand. Completely. Permanently. She learned to write with her left hand at 70 years old. Her signature changed. Shaky now. Tilted left. Nothing like before. But she still made breakfast every morning for Wesley and Willa. Still sat on that porch swing. Still told them the same thing their grandfather used to say. This land is paid for. This land is ours. Don't you ever let nobody take it with a pen. Wesley was the quiet one. The kind of quiet that makes people nervous because they can't figure out what you're thinking. He started reading law books at the public library when he was 14. Not for school. Not for a grade. Because one day he watched a landlord threaten Miss Alma down the street with an eviction notice, and nobody could tell him whether it was legal or not. So he decided he would know. By 18, Wesley had read more Georgia property code than most first-year law students. He kept a brown leather notebook. His grandmother gave it to him on his 16th birthday. Every page filled with case notes, statutes, questions. Willa was different. Willa was sharp, the way a blade is sharp. Fast, precise, and impossible to ignore once she moved. She had a photographic memory. Read a page once, remembered the whole thing. While Wesley studied the law, Willa studied the system. County records, public filings, online databases. She could find a document the state forgot it had. Together, they were something nobody in Colton Springs expected. But Colton Springs wasn't paying attention to Wesley and Willa Lewis. Colton Springs was paying attention to Brent Calloway. Calloway owned Colton Ridge Estates, the biggest real estate development company in the county. He had plans for Cedar Hill. Big plans. Luxury homes, golf views, a gated community with a waiting list. There was just one problem. Black families lived on Cedar Hill. 6 of them. One by one, those families disappeared. Some sold cheap after months of pressure. Some got tangled in lawsuits they couldn't afford to fight. Some just gave up. Gerald Haynes handled every single one of those cases. Haynes was Calloway's lawyer, 58 years old, 30 years of real estate litigation. He hadn't lost a land case in 15 years. His office sat on Main Street, glass doors, gold lettering, the kind of place that tells you the man inside charges more per hour than most people in Colton Springs earn in a week. 6 families gone, 6 lots cleared. Dorothea Lewis was the last one left. On a Tuesday afternoon in June, a certified letter arrived at the white clapboard house on Cedar Hill. Colton Ridge Estates was suing Dorothea Lewis for possession of her property. The claim said she had signed a deed transfer in 2022, giving the land to Callaway's company. Dorothea held the letter in her left hand. Her right hand sat motionless on the armrest of her wheelchair. "I never signed anything," she said. "I would never." Wesley stood in the doorway, watching his grandmother read that letter. He saw her hand tremble. He saw her eyes fill. And right then, standing in that doorway, Wesley Lewis made a decision that would put him face to face with the most powerful lawyer in Colton Springs. If you think this story ends with an old woman losing her home, stay right here. Because what these two 18-year-olds did next will change how you see justice. Wesley started making calls the next morning. 9 law firms in Colton County. He called every single one. The first one picked up on the second ring. A receptionist with a polite voice and a fast answer. "I'm sorry, we have a conflict of interest with that case. We can't help you." Conflict of interest. That meant Colton Ridge Estates was already their client. The second firm said the same thing. Different words, same answer. "We're unable to take on new cases involving that property dispute at this time." The third firm didn't even pretend. "Son, Gerald Haynes is on the other side of that case. Find somebody else." 3 calls, 3 closed doors. Wesley kept dialing. Firms 4 through 6 quoted him a retainer fee. The cheapest was $5,000. One wanted $8,000 just to review the paperwork. Wesley looked at the bank statement taped to the refrigerator. His grandmother's savings account. $1,200.16. That's what 38 years of teaching in Colton Springs gets you when you're a black woman with a pension and a mortgage that took 4 decades to pay off. Firms 7 and 8 didn't answer. Wesley left voicemails. Nobody called back. Firm 9 picked up. A young paralegal listened to the whole story. She sounded like she cared. Then she put Wesley on hold for 4 minutes, came back and said, "I'm really sorry. We just can't." 9 calls. 9 doors shut in his face. Willa tried a different route. She found the Legal Aid Society online. Free representation for people who couldn't afford lawyers. She filled out the application that same night. Every question, every document. The response came 3 days later. An email. 1 paragraph. "Thank you for your application. Due to current caseload, our estimated wait time for new property cases is approximately 4 months. The court date was in 3 weeks. 4 months. 3 weeks. The math didn't work. The math was never designed to work, not for people like Dorothea Lewis. Meanwhile, Gerald Haynes was moving fast. 2 days after the lawsuit was filed, a white pickup truck pulled into the dirt driveway on Cedar Hill. 2 men got out. White, polo shirts, clipboards. They walked the property like they owned it already. Measuring tape along the fence line. Photographs of the house, the porch, the oak trees. Willa stepped outside. "Can I help you?" One of them didn't even look at her. "Property survey, ordered by the new owners." "There are no new owners," Willa said. The man finally turned, looked at Willa the way you look at a child who interrupts an adult conversation. "Ma'am, we're just doing our job. You'll want to take that up with the court." They spent 45 minutes on Dorothea's land, walking, measuring, writing things down. And when they left, they didn't close the gate behind them. Dorothea watched from the window. She didn't say a word, but that night, her blood pressure spiked so high that Wesley drove her to the emergency room at Colton Springs General. The doctor kept her overnight. "Observation," they said. "Stress-related hypertension." Wesley sat in the waiting room until 2 in the morning. Fluorescent lights buzzing overhead. The smell of disinfectant and old coffee. His grandmother was 75 years old, in a hospital bed, because 2 strangers walked onto her land like it was already theirs. And somewhere across town, Gerald Haynes was sleeping fine. Clarence Dobbs showed up at the hospital the next day. 68 years old. lived 3 houses down from Dorothea for 40 years. He brought soup in a plastic container and the kind of look on his face that said he'd seen this before. "They did the same thing to my cousin over on Birch Road," Clarence said. He sat down slowly, knees aching. "Showed up with papers she never signed. By the time she found somebody to help, the bulldozers were already on her lot." He looked at Wesley, then at Willa. "Your grandmother is the last one, you know. Last black family on the hill. They get her land, Cedar Hill is done." Wesley didn't answer. He was holding his brown leather notebook, turning it over and over in his hands. That night, Willa sat alone in the hospital parking lot, engine off, windows up, and for the first time since the letter arrived, she cried. Not loud, not dramatic, just tears rolling down her face in a dark car in a hospital parking lot at 11 at night. Because she was 18 years old, because her grandmother was upstairs in a hospital bed, because a man with gold cufflinks and a 30-year winning streak was about to take the only home she had ever known, and because nobody, not one person in the entire county, would help them. Wesley found her there 20 minutes later. He opened the passenger door, sat down, and put his hand on her shoulder. He didn't say it's going to be okay. He didn't say we'll figure it out. He didn't say any of the things people say when they don't know what else to say. He just sat there, in the dark, in the quiet. And after a long time, Willa wiped her face and said, "What are we going to do?" Wesley opened his notebook. He turned to a page near the back, where he had written something in small, careful handwriting. "I've been reading the lawsuit again," he said. "The deed transfer. It's dated March 15th, 2022. So the signature on it, Grandma's signature, it's smooth, even, right-handed." Willa looked at him. "Grandma hasn't used her right hand since 2019, Willa. 3 years before that deed was signed." The parking lot was silent, just the hum of a streetlight above them. Willa's eyes changed. That fast, sharp thing she does when something clicks, like a lens snapping into focus. "They forged it," she whispered. "They forged it," Wesley said. And for the first time in 2 weeks, something other than fear showed up on their faces. It wasn't relief. It wasn't confidence. It was smaller than that, quieter. It was a reason to keep going. I tell this story because I've watched grown men with law degrees do less than what these 2 kids did in a parking lot at midnight. 18. No money, no backup. And still they chose to fight. Not bravery they learned. That's bravery they were born with. The next morning, Wesley was sitting at the kitchen table before sunrise. His grandmother's brown leather notebook was open in front of him. The first page. Her handwriting, back when her right hand still worked. Tall letters, steady strokes. "The law is a shield, not a sword, but you have to know how to hold it." She wrote that for him on his 16th birthday, 2 years ago. He had read it 100 times since. But that morning, sitting in the gray light before dawn, it meant something different. It meant nobody was coming. Willa came downstairs at 6. She found Wesley at the table, still in last night's clothes, the notebook surrounded by printed pages from the county clerk's website. "How long have you been up?" she asked. "I didn't sleep." She sat down across from him, looked at the pages, looked at his face. "We're doing this ourselves," Wesley said. It wasn't a question. "We're 18, Willa said. "Georgia doesn't require a lawyer for civil cases. If Grandma gives us power of attorney, we can represent her. I looked it up last night." Wesley closed the notebook. "Then we need her to sign." They brought the paperwork to Dorothea that afternoon. She was home from the hospital, back in her wheelchair on the porch. The oxygen tank beside her hummed softly. Wesley explained everything. The forged signature, the right hand problem, what they wanted to do. Dorothea listened without interrupting. When he finished, she looked at both of them for a long time. The porch swing creaked in the breeze. A mockingbird sang from the oak tree. You're asking me to let my 18-year-old grandchildren walk into a courtroom against Gerald Haynes? Yes, ma'am. The man who hasn't lost a case in 15 years. Yes, ma'am. She reached out with her left hand, took the pen. Her fingers trembled, but her eyes didn't. She signed, shaky letters, tilted left. Nothing like the smooth, right-handed signature on that forged deed. Your grandfather bought this land with hands that picked cotton, she said. Don't you let them take it with a pen. The next 18 days were the longest of their lives. Wesley practically lived at the Colton Springs Public Library, 8 in the morning until 9 at night, every day. The same table by the window, stacked with books he couldn't check out because they were reference only. Georgia Property Code, Title 44, Chapter 14, Fraud in Real Estate Transactions. He read every section. Then he read the case law. Then he read the case law referenced in the case law. He took notes in the brown leather notebook until the pages ran out. Then he bought a second notebook from the dollar store, filled that one too. The librarian, a white woman in her 60s named Ruth, watched him for 3 days before she finally asked what he was working on. A property case, Wesley said. She didn't ask anything else. But the next morning, she had moved 2 additional volumes of Georgia real estate law to his table. A sticky note on top read, "These might help. Small kindness." The only one he got from anyone outside his family during those 18 days. Willa worked from home. The old desktop computer in the living room that took 3 minutes to boot up and crashed if you opened more than 4 tabs. She taught herself to navigate the county record system, property transfers, deed filings, notary registrations. She built a timeline on the living room wall. Sticky notes, colored markers, dates on the left, names on the right, connections drawn in red ink. March 15th, 2022. Date on the forged deed. September 8th, 2021. The day Dale Perkins lost his notary license. November 2019. The date of Dorothea's stroke. The timeline told a story, a simple one. A deed signed by a hand that couldn't sign. Notarized by a man who couldn't notarize. Filed by a lawyer who knew both of those things. Every night the twins practiced. Wesley stood in front of the bathroom mirror and rehearsed his opening statement. The first time, his voice cracked on the second sentence. The 5th time, his hands were still shaking. The 10th time, he got through the whole thing without stopping. Willa sat cross-legged on the hallway floor, playing Gerald Haynes. "Objection, Your Honor. These children have no standing," Wesley answered. "Your Honor, we hold legal power of attorney. Standing is established under Georgia Code." "Louder," Willa said. "He's going to talk over you. Be louder." They went back and forth until 2 in the morning. Every night. For 18 nights. And on the last night, the night before the hearing, Willa said something that Wesley wrote down in his notebook and underlined twice. "Don't try to out-talk him, Wesley. He's got 30 years of that. You won't win a shouting match with Gerald Haynes." She looked at her brother. "Ask the right question. One question. That's all you need." Wesley stared at her. Then he picked up his pen and wrote something on the last page of the notebook. Small letters, careful handwriting. He didn't show Willa what he wrote. The morning of the hearing, Wesley and Willa put on the best clothes they owned. White shirts, dark pants, shoes that were old but polished until they caught the light. Dorothea was already on the porch when they came downstairs. Wheelchair parked by the front steps. A cup of coffee in her left hand, steam rising in the early air. Cedar Hill was quiet. Morning fog rolling through the oak trees. Birds just starting. The smell of red clay and coffee and something else. Something old and deep, like the land itself breathing. Dorothea looked at her grandchildren. 18 years old. Orphaned at 6. Raised on a teacher's pension and a piece of land that somebody decided was worth more without black people on it. She set the coffee down, reached for Wesley's hand. "I've been teaching children for 38 years, she said. "I taught every one of them the same thing. Stand up straight, speak clearly, And never let anyone make you believe you don't belong in the room. She squeezed his hand. You belong in that room. Wesley picked up the 2 file folders from the porch railing. Dollar store folders, plastic covers, already cracking at the spine. Inside, every piece of evidence he and Willa had found in 18 days of no sleep, no money, and no help. He put the brown leather notebook in his back pocket. And the Lewis twins walked off Cedar Hill toward the Colton County Courthouse, where Gerald Haynes, 30 years undefeated, was already inside, adjusting his gold cufflinks, expecting the easiest win of his career. He had no idea what was coming. The night before the hearing, Wesley almost missed it. He was sitting at the kitchen table at 11:45, eyes burning, coffee cold. He had been staring at the same scanned copy of the deed transfer for 20 minutes, going over details he had already memorized. Dorothea's name at the bottom, the date, March 15th, 2022, the notary seal, Dale Perkins, everything he already knew. He was about to close the laptop when something caught his eye, the signature. He had looked at it 100 times, but this time he wasn't looking at the name. He was looking at the angle, the slant, the pressure of the pen. Smooth, even, tilted slightly to the right. The kind of handwriting that comes from a steady, dominant right hand. Wesley turned his head, looked at the power of attorney form on the table beside him. His grandmother had signed it 3 days ago. Left hand. The letters were shaky, uneven, tilted left. The pen had skipped twice because her grip wasn't strong enough to keep consistent pressure. 2 signatures, same name, completely different hands. His grandmother hadn't used her right hand since 2019. The deed was dated 2022. Wesley's chest went tight. He pushed back from the table. Willa, come here. She was in the living room, half asleep on the couch with her laptop open. She came to the kitchen and stood behind him. Wesley put the 2 documents side by side. Didn't say a word, just pointed. Willa looked. 5 seconds. 10 seconds. They forged it, she said. They forged it. But Willa was already moving. She sat down, pulled the laptop toward her, and opened the Georgia Secretary of State website. Notary Public Database. Search function. She typed, Dale Perkins, Colton County. The result loaded in 3 seconds. Dale Raymond Perkins. Notary commission revoked. Effective date, September 8th, 2021. Willa read it twice, then a third time. Her hand was shaking on the trackpad. The deed said Dale Perkins notarized Dorothea's signature on March 15th, 2022. But Dale Perkins hadn't been a legal notary since September 2021, 6 months before he supposedly stamped that seal. A forged signature, a dead notary seal. The deed wasn't just fraudulent, it was built on 2 lies stacked on top of each other. Willa printed the page. The old printer in the corner groaned and spit out a single sheet. Wesley, she said quietly, this deed isn't just forged. It's notarized by a man who legally couldn't notarize anything. Wesley nodded, but he wasn't done. He opened the county court filing system. Every case had a public docket. He pulled up their case number and scrolled through the filings, and there it was, an amended deed filing, submitted by Gerald Haynes, time-stamped 6:15 that morning, 2 hours before the hearing. Wesley clicked on it. The amendment changed the property boundary description. Small adjustments, minor language, nothing dramatic. But the question screamed in Wesley's head louder than anything Gerald Haynes had ever said in a courtroom. Why would you amend a deed the morning of the hearing, unless you knew the original couldn't survive what was coming? Gerald knew. He already knew the deed had problems. And instead of withdrawing the case, he tried to patch the holes 2 hours before a judge would see them. Wesley closed the laptop, looked at Willa. I know my one question. Willa tilted her head. What is it? Wesley didn't answer. He pulled the brown leather notebook from his back pocket, opened it to the last page, and wrote 1 sentence underneath the words he had written the night before. Then he closed the notebook and put it back in his pocket. You'll hear it when everyone else does. The Colton County Courthouse smelled like floor wax and old wood. Wesley noticed that first. Then the fluorescent lights buzzing overhead, one of them flickering near the back wall. The ceiling was low. The paint was yellowing. A ceiling fan turned slowly above the judge's bench, doing nothing about the heat. This wasn't a courtroom from a movie. This was a small-town room where small-town people came to settle small-town disputes. Traffic tickets, fence lines, noise complaints. Today it would decide whether a 75-year-old black woman kept the land her family had owned for 62 years. Gerald Haynes was already seated at the plaintiff's table. Gray suit, Italian leather briefcase. 2 junior associates beside him. Matching navy ties, matching posture, matching silence. 3 men who looked like they had walked out of a catalog. On the other side of the aisle, the defendant's table had 2 plastic folders from the dollar store and a brown leather notebook. Wesley and Willa sat down. Behind them, Dorothea's wheelchair clicked into place. She folded her left hand over her right and said nothing. The gallery was almost empty. Clarence Dobbs in the second row, still wearing his work boots. 2 neighbors from Cedar Hill. A woman in the back corner Wesley had never seen before. Mid-50s, dark blazer, watching everything with the kind of attention that doesn't blink. Nobody knew who she was. Not yet. The side door opened. The bailiff stepped out. All rise. The Honorable Judge Eleanor Crawford presiding. Crawford entered, 62 years old, silver hair pulled tight, reading glasses on a chain around her neck. She sat down, opened a folder, and scanned the room the way a woman does when she's been doing this for 30 years and already knows more than everyone thinks she does. Be seated. Case number 24-1152. Colton Ridge Estates versus Dorothea Lewis. Mr. Haynes, you may proceed. Gerald stood, buttoned his jacket, gave the judge a nod like they were old friends at a dinner party. Thank you, Your Honor. This is a straightforward matter. My client, Colton Ridge Estates, holds a valid deed transfer executed by the defendant in March of 2022. The property in question, 2.4 acres on Cedar Hill, was legally conveyed. We are simply asking the court to enforce what is already settled. He smiled. The smile of a man who had done this 60 times before and never once been told no. I expect this will take no more than 15 minutes of the court's time. Crawford looked at the defendant's table. Does the defendant have counsel? Wesley stood. His chair scraped against the floor. The sound was loud in the quiet room. Your Honor, my name is Wesley Lewis. This is my sister, Willa Lewis. We're representing our grandmother, Dorothea Lewis, under her signed power of attorney. Gerald turned his head, slowly, the way a cat turns towards something it finds amusing. Your Honor, Gerald's voice carried the kind of amusement that cuts deeper than anger. Are we proceeding with this? 2 teenagers? I have been practicing law for 30 years. This is not a school debate club. Someone in the gallery coughed to cover a laugh. Crawford didn't smile. She looked at Wesley over her reading glasses. Mr. Lewis, do you understand the nature of these proceedings? Yes, Your Honor. This is a civil action for property possession filed under Georgia Code Title 44. The burden of proof rests on the plaintiff to establish a valid deed of conveyance. We intend to demonstrate that the deed in question is void. The room shifted. Not a sound, more like a feeling. The way air changes before a storm. Crawford's eyebrows lifted a fraction of an inch. Proceed. Gerald's smile didn't disappear, but it thinned. He recovered quickly, turned to the judge and presented the deed. A clean photocopy projected on the screen. Dorothea Lewis, March 15th, 2022. Notarized by Dale Perkins. Recorded in the county clerk's office. The document speaks for itself, Your Honor. Signed, notarized, recorded. I fail to see what there is to contest. Wesley stood again. Your Honor, may I examine the original document? Gerald hesitated. 1 second, maybe 2. Then he handed it over. Wesley held the paper, looked at it, turned it once, set it down on the table, picked up his pen and wrote a single line in his notebook. Gerald watched him. Is the young man finished with his examination? He leaned on the words young man like they tasted good. Wesley didn't respond to Gerald. He looked at the judge. Your Honor, I would like to enter into evidence Exhibit A, a certified medical record from Colton Springs General Hospital, dated November 2019, confirming that Dorothea Lewis suffered a stroke resulting in complete and permanent paralysis of her right hand. He paused. Let the room hear the silence. The signature on this deed was made by a right hand. My grandmother has not used her right hand since 2019. This deed is dated 2022. Nobody laughed. Nobody moved. Gerald Haynes stood very still. For the first time in the entire proceeding, his mouth was closed. Crawford looked at Gerald. Her voice was level, but her eyes were not. Mr. Haynes, would you like to respond? Gerald straightened his tie. That is a matter of handwriting interpretation, Your Honor, not a medical fact. But his voice had changed. Just a fraction. Just enough. And the woman in the back row, the one in the dark blazer, leaned forward in her seat. Gerald Haynes didn't become the most powerful real estate lawyer in Colton County by panicking. He took 3 seconds, adjusted his cuffs, and came back swinging. Your Honor, I must object to this entire line of argument. His voice was steady again, controlled. 30 years of courtroom muscle memory kicking in. A stroke does not necessarily eliminate all hand function. Many stroke patients experience partial recovery. Mrs. Lewis may well have regained limited use of her right hand by 2022. He turned toward Wesley, not looking at him, looking past him, the way you look past something that doesn't matter. These are children, Your Honor. They have no medical expert, no handwriting analyst, no qualified witness of any kind. What they have is a hospital record and a theory. I could bring a hospital record showing I had a cold last winter. That doesn't mean I can't hold a pen today. Soft laughter from one of Gerald's associates. Nobody else laughed. Gerald pressed harder. I move to exclude the medical record as irrelevant, without expert testimony to establish a direct connection between the defendant's condition and her ability to sign. The room held its breath. Crawford leaned back in her chair. She looked at the medical record, then at Wesley, then at Gerald. This was the moment. Wesley felt it. If Crawford excluded the medical evidence, their strongest argument was gone. Everything they had built in 18 sleepless nights would collapse in a single ruling. His stomach dropped. His fingers went cold around the pen in his hand. Crawford opened her mouth, and Willa stood up. Your Honor, may I address the notarization? Every head in the room turned. It was the first time Willa had spoken. The first time anyone other than Wesley had spoken from the defendant's table. Gerald's eyes narrowed. He hadn't prepared for 2 of them. Crawford paused, looked at Willa, nodded once. You may. Willa's voice was calm, quieter than Wesley's, but it carried. Your Honor, I'd like to enter Exhibit B into evidence. This is a certified printout from the Georgia Secretary of State's Notary Public Database. She held up the page. The one the old printer had groaned out the night before. The deed transfer presented by Mr. Haynes was notarized by Dale Raymond Perkins. According to the state's own records, Mr. Perkins's notary commission was revoked on September 8, 2021. She let that sit for 1 second. The deed is dated March 15, 2022. That is 6 months after Mr. Perkins lost his legal authority to notarize any document. Under Georgia Code Section 45-17-8, a document notarized by an individual whose commission has been revoked is void. She set the printout on the table, folded her hands. The deed is not just questionable, Your Honor. It is legally invalid on its face. The gallery stirred. Clarence Dobbs leaned forward. The woman in the dark blazer hadn't moved, but her eyes had. Gerald was on his feet before Willa finished sitting down. Objection. The notary's status is entirely irrelevant to the validity of... Overruled, Crawford said at once. Flat. Final. Sit down, Mr. Haynes. Gerald sat. His jaw tightened. The associate beside him slid a note across the table. Gerald didn't read it. Crawford removed her glasses, set them on the bench, looked at the clock on the wall. This court will take a 30-minute recess. We will reconvene at 11:15. The gavel came down, sharp, loud in the small room. Mr. Haynes, I suggest you use that time wisely. People stood, chairs scraped, voices murmured, but Wesley's eyes were on Gerald. Gerald pulled out his phone before he was even through the side door, dialing fast. He pressed the phone to his ear and turned the corner into the hallway. Wesley caught 3 words before the door closed. We have a problem. Who was on the other end of that call? Brent Calloway? Dale Perkins? Someone else? Wesley didn't know. It didn't matter. Not right now. Out in the hallway, Wesley leaned against the wall. Willa stood beside him. For the first time, she noticed his hands. They were shaking. You okay? She asked. He almost got the medical evidence thrown out. If Crawford had sided with him. She didn't. But she could have. Willa put her hand on his arm. We still have your question, Wesley. The one you won't tell me. Wesley reached into his back pocket, felt the leather notebook, the last page, the sentence he had written at midnight. I know. Behind them, the courtroom door opened. Dorothea rolled her wheelchair into the hallway. She looked at her grandchildren, one shaking, one steady, both still standing. She reached out her left hand and took one of each of theirs. I'm proud of you, she said, no matter what happens in there. And somewhere on the other side of the courthouse, Gerald Haynes was pacing a hallway with his phone to his ear, talking fast, sweating through his gray suit, trying to fix something that 2 18-year-olds with dollar store folders had just broken wide open. When court resumed, Gerald Haynes looked different. Not broken, not scared, but different. The jacket that had been buttoned was now open. The tie that had been perfectly centered had shifted a 1/4 inch to the left. Small things. The kind of things only someone paying very close attention would notice. Wesley noticed. Gerald came out aggressive. A new strategy. If you can't defend the document, attack the people questioning it. Your Honor, before we continue, I must put something on the record. Gerald stood with both hands on the plaintiff's table. The individuals representing the defendant have no legal training, no bar admission, no professional standing of any kind. They are 18 years old. He let the number hang in the air. What we've witnessed this morning is not legal argument. It's amateur research presented by 2 young people who have confused Google searches with courtroom expertise. I urge the court to weigh their so-called evidence accordingly. He sat down, satisfied. The kind of satisfied that comes from knowing you've just reminded everyone in the room who the adult is. Crawford looked at him for a long moment. Then she spoke. Mr. Haynes, the respondents hold valid power of attorney. They have standing. The evidence they have presented comes from certified state databases and accredited medical records, not, as you suggest, from internet searches. She paused. Continue. Gerald's jaw tightened. The associate beside him stopped writing. Crawford turned to the defendant's table. Mr. Lewis, do you have anything further? Wesley stood, slowly. The room was quiet. The ceiling fan turned. The fluorescent light in the back still flickered. Your Honor, I have one question for Mr. Haynes. Crawford nodded. Go ahead. Wesley stepped around the table. He didn't approach Gerald. He didn't need to. He stood right where he was, in his too big white shirt with his dollar store folder, in a courtroom that had laughed at him 2 hours ago. He looked directly at Gerald Haynes. Mr. Haynes. Gerald looked up. The expression on his face said, Go ahead, boy. Ask your little question. If this deed is authentic, if it is valid and legally binding, as you have told this court, then why did you file an amended version of it at 6:15 this morning, 2 hours before this hearing began? Silence. Not quiet. Silence. The kind that has weight, the kind that presses against your eardrums. The ceiling fan turned. Somewhere in the gallery, someone inhaled sharply. Clarence Dobbs gripped the bench in front of him. Gerald didn't answer. 1 second. 2 seconds. 3. Crawford leaned forward. "Mr. Haynes, answer the question." Gerald cleared his throat. That was a routine administrative correction, a clerical adjustment to the property boundary description, nothing more. Wesley didn't flinch. A clerical adjustment to a document you just told this court was authentic and complete as originally filed. He turned to the judge. "Your Honor, I'd like to enter Exhibit C. This is the court's own electronic filing log, showing an amended deed submitted by Mr. Haynes at 6:15 a.m. today. I also have a side-by-side comparison of the original deed and the amended version." Wesley laid both documents on the table, carefully, the way his grandmother once laid out lesson plans on this same kind of wooden surface. The amendment changes the property boundary description to match a new survey commissioned by Colton Ridge Estates last month. The original deed references boundary lines that don't align with current county records. He looked at Crawford. "If the original deed was genuine, Your Honor, it wouldn't need corrections. If it was a real document, signed by a real person, notarized by a real notary, it would match the records as they were in 2022. Wesley's voice didn't waver, didn't rise, didn't perform. "Mr. Haynes amended this deed at 6:15 this morning because he knew the original would not survive today. He didn't expect anyone to check. He didn't expect anyone to pull the notary database. He didn't expect anyone to compare the boundary descriptions." Wesley paused. 1 beat. 2. "He didn't expect us." The courtroom was so still, you could hear the fluorescent light buzzing in the back corner. Gerald stood up. His face had gone red from the collar up. "This is outrageous. I will not be cross-examined by a child. Your Honor, I demand—" "Mr. Haynes," Crawford's voice cut the room like a blade. "You will address this court with respect, and you will answer the question I have now asked you twice. Why was the deed amended this morning?" Gerald opened his mouth, closed it, opened it again. Nothing came out. 30 years of courtroom arguments, 30 years of winning, and Gerald Haynes could not find a single word to say. The woman in the dark blazer sat perfectly still in the back row. Her hands were folded in her lap. But if you looked closely, very closely, you could see she was nodding. One question. That's all it took. One question from an 18-year-old in a borrowed shirt, standing in a courtroom that laughed at him before he ever opened his mouth. If this moment just gave you chills, hit that like button right now, and share this with someone who's been told they don't belong in the room. Judge Crawford didn't speak right away. She looked at the deed, then the amended filing, then the notary database printout, then the medical record. 4 documents, laid out in front of her like pieces of a puzzle that had already been solved. The courtroom waited. Gerald Haynes sat with his hands flat on the plaintiff's table. His associates had stopped writing. One of them had quietly closed his briefcase, the kind of small, unconscious movement that says everything about what a man believes is coming next. Crawford put her glasses back on, opened a notepad, wrote something. Then she looked up. "I've heard enough." She folded her hands. "The court finds that the deed transfer presented by Colton Ridge Estates is invalid, on multiple grounds." Her voice was steady, measured. The voice of a woman who had delivered hundreds of rulings, but understood that this one mattered more than most. First, the signature on the deed does not match the known physical capabilities of Mrs. Dorothea Lewis, who has been unable to use her right hand since November of 2019. The deed is dated 2022. Second, the notarization was performed by Dale Raymond Perkins, whose notary commission was revoked 6 months prior to the date on the document. Under Georgia law, this alone renders the deed void. Third, the plaintiff's own last-minute amendment to the deed, filed just 2 hours before this hearing, fatally undermines any claim of authenticity. If the document were genuine, it would not require correction on the morning it was to be examined by this court. Crawford looked directly at Gerald. The case is dismissed, with prejudice. Mrs. Dorothea Lewis retains full and undisputed ownership of her property on Cedar Hill. She paused. The ceiling fan turned once, twice. Furthermore, I am referring this matter to the Georgia State Bar Association for investigation into potential fraud, fabrication of evidence, and professional misconduct by counsel for the plaintiff. The gavel came down. One sound, sharp, final. It echoed off the low ceiling and the old wooden walls and the fluorescent lights, and it landed somewhere deep in the chest of every person sitting in that room. For one full second, nobody moved. Then, Clarence Dobbs stood up. Slowly, the way a 68-year-old man with bad knees stands up when something matters enough to hurt for. He brought his hands together. One clap, then another. The woman beside him stood, then the man behind her, then the whole second row. It wasn't loud. It wasn't a movie moment. It was a small courtroom in a small town in Georgia, and maybe a dozen people clapping, but it sounded like the whole world finally paying attention. Dorothea Lewis sat in her wheelchair with tears running down her face. Her left hand pressed against her chest. Wesley knelt beside her. Willa knelt on the other side. They didn't say anything. They just held her. 3 people, 1 wheelchair, 62 years of land under their feet, and a lifetime of being told it didn't really belong to them. Gerald Haynes packed his briefcase. He didn't look at the judge, didn't look at the gallery, didn't look at Wesley or Willa or the old woman in the wheelchair. He walked out through the side door. His 2 associates followed with their heads down. The door clicked shut behind them. In the hallway, Gerald passed Clarence Dobbs. Clarence was standing by the water fountain. He didn't say a word, just looked at Gerald with 68 years of Cedar Hill in his eyes. Gerald kept walking. That was enough. The woman in the dark blazer waited until the courtroom had nearly emptied. Then she stood, straightened her jacket, and walked to the defendant's table. "My name is Patricia Stanton," she said. "I'm the director of the Equal Justice Initiative's Southern Regional Office." Wesley and Willa looked at her. Dorothea looked at her. "I came here today to observe a different case on the docket, but I watched every minute of what just happened." She looked at Wesley, then at Willa. "I've supervised third-year law students who cannot do what you 2 just did in this room." She reached into her jacket and set a business card on the table. "I'd like to talk to both of you about a full scholarship. Law school. Both of you, if you're interested." Willa looked at Wesley. Wesley looked at Dorothea. The old woman smiled. The kind of smile that starts slow and fills the whole face and costs a woman her last bit of composure. "Go on," Dorothea said. "Answer the lady." Wesley picked up the card. His hands weren't shaking anymore. 6 months later, Wesley and Willa Lewis started their first semester in a pre-law program at Georgia State University. Full scholarships. Both of them. Patricia Stanton made the call herself. Wesley still carries the brown leather notebook. The pages are full now. Both notebooks are. But he bought a third one the week classes started. Same kind. Same size. The woman at the bookstore asked if he was a writer. "No, ma'am," he said. "I just like to be prepared." Willa declared a double concentration, constitutional law and civil rights litigation. Her advisor told her that was ambitious for a first-year student. Willa told him she'd already won a case. He didn't ask again. Back on Cedar Hill, the white clapboard house is still standing. The porch swing still creaks. Dorothea still sits there every morning with her coffee in her left hand, watching the oak trees do what they've done for 60 years. Grow. 3 other black families on Cedar Hill reached out to Wesley after the hearing. They wanted him to look at their deeds. He did. 2 of them had the same notary stamp. Dale Perkins. Same revoked seal. Same lie. Those cases are pending now. Clarence Dobbs told his wife about it over dinner one night. She asked him if he thought things were finally changing in Colton Springs. Clarence thought about it for a long time. Then he said, 60 years I've lived on that hill. First time I believe somebody's actually watching out for us. Gerald Haynes is under investigation by the Georgia State Bar. Colton Ridge Estates quietly withdrew all pending land claims on Cedar Hill. Brent Calloway has not been seen at the county courthouse since. Nobody in Colton Springs talks about Gerald Haynes the way they used to. Wesley Lewis didn't have a law degree. He didn't have a suit that fit. He didn't have money or connections or 30 years of experience. He had a grandmother who taught him to read, a sister who taught him to fight, and one question that nobody in that courtroom saw coming. I chose this one because I'm tired of watching people decide what you're worth before you open your mouth. Wesley and Willa walked into that room with nothing but preparation and nerve. 18 years old, no degree, no backup, and they still made a grown man forget how to speak. If you felt something watching this story, I need you to do 3 things. First, hit that subscribe button. Stories like this deserve to be told, and this channel exists because you keep showing up for them. Second, share this video with someone who's been counted out, someone who's been laughed at, someone who's been told they don't belong in the room. Send it to them right now. Third, drop a comment. I want to know, if you were standing in that courtroom at 18 years old, no lawyer, no money, your grandmother's home on the line, would you have had the courage to ask that one question? And if you think you caught everything, watch it again. There's a detail in the first 2 minutes you missed, I promise. We'll see you in the next one.